Well, the concerns of startups and digital ad agencies can be actually overlapping but not identical. When you're a startup, you're going to be first concerned about money, of course, and some of the startup issues you would expect, getting office space, getting employees, and so on. Once you've got yourself going, then we get into the areas of overlap. Intellectual property, a big issue for both types of entities. You have to worry about protecting your intellectual property, making sure others are not stealing it. And when I say others, that can include your clients. You have to be careful that in your engagement agreements, your master services agreements, you haven't accidentally given away your IP to your clients. And of course, you've got to be worried about using other people's IP and getting sued over that, and the basics of protecting IP, whether it's filing patents or trademarks or copyrights. That pertains for all those entities. And data and privacy, always big issues in this digital realm. Whether you have the right to use the data you want to use, whether some third party is going to capture data you don't want them to use in connection with your services, your ad campaigns, whatever it is you're doing, whether you're violating the law in capturing certain data and using it, and whether you have an appropriate privacy policy, all critical issues for both those entities. One more set of issues to worry about if you're a digital ad agency, of course, is you're kind of stuck in the middle more than most startups are, because you have your client on the one hand, and you have a bunch of third parties, media vendors, media technology companies on the other hand. You're trying to manage those relationships, and oftentimes you can get caught in the middle, left holding the bag, and there are a lot of legal issues that surround that as well. So there's a lot of overlap, but there are a couple of distinctions between those sorts of entities. Well, with respect to your question about how do you respond in an always-on world, my answer is education, preparation, because if you're prepared, it's going to be a lot easier to respond. So for a lot of our clients, we recommend training and guidelines so that they know how to respond when a situation arises. For example, if you're a company that's producing widgets, particularly a dangerous widget, and there can be a product liability issue, you want to train people that when that product liability question or issue arises in social media, when someone says, oh my God, the widget just blew up, you have to know how to respond to that. You can't just have a willy-nilly response. There has to be a set of procedures and protocols you follow. Otherwise, you're in trouble. The same pertains to use of intellectual property. If you see some infringement going on, or you may be having people who are potentially infringing intellectual property, you need to train them what you can and cannot do. And that's just the best way to respond to this sort of real-time world. It looks spontaneous, but the best responses are not spontaneous. They've been planned, they've been thought out. Otherwise, true spontaneity can get you in a lot of trouble. Well, the example you're starting right now, the use of Super Bowl in advertising, is a subset of the broader issues we've been talking about. How do you deal with this real-time world? So in the case of the Super Bowl and a lot of social media around Super Bowl, we prepared guidelines for clients and protocols that they can follow and some rules of the road before the event even took place. So as you suggest, use of the word Super Bowl is a clear no-no. That's going to violate trademark rights. But there are alternative terms like the big game, which is much lower risk. And you have to have your people prepared ahead of time. Is it riskier to say the Broncos or to say Denver? Is it riskier to talk generally about what's going on or tweet generally about what's going on versus invoking the specific name of a player? You have to know the answers to those questions and be prepared before the event occurs, and that's how you deal with the real-time world and how you deal with events like that in this day and age. Well, the question you're asking about the future of wearable technology, it's a very interesting question because there's been a lot of controversy about wearable technology. In a lot of respects, wearable technology that we know, like Google Glass, it's not that much different from your average iPhone. It does a lot of the same sorts of things. What concerns people about that sort of technology is they feel that it's doing data capture in ways that are less apparent than your typical device. So someone might argue, for example, that if you're wearing Google Glass, they have no idea that you're being recorded, that they're being recorded. And whether that's true or not is debatable, but that's a fear. And in fact, you've got some hostility sometimes to people wearing those sorts of devices. There was concern about facial recognition software being utilized by Google, and Google's now said it's not going to do that. There's also concern that since these are almost biometric devices, would they be measuring some sensitive health data as soon as you put them on? And I think there have been efforts to allay some of those concerns. So I think the answer is, if you can address some of those concerns either with arguments like, when you're holding up a phone, you could be recording someone and they might not know about it, so how's it any different from Google Glass, or whether it's agreeing not to gather certain data. If you really do make those sort of wearable devices essentially the same as a phone, I think that the future is bright, at least from a legal perspective. They're not going to raise different privacy concerns if you address those concerns up front by essentially agreeing not to gather certain types of data or make it apparent when you are and get consumer consent.